Good morning. Let us resume today again with the president. So, president is a very large topic, I told you. So, we have been discussing the president of India for quite long period of time. So, that shows the elaborate nature of the president of India. So, now we'll see another power of the president. That is the ordinance making power of the president. I'll just show you the document and again I'll come back to you. Look at the spelling. So, this is the meaning of the ordinance making power, right? Now, so now let's try to understand what exactly is the meaning of the so-called this ordinance making power. And before that one, kindly remember one point. Ordinance making power is considered to be the most important legislative power of the president. We have understood lots of terminology in our previous classes. So now we'll try to use that knowledge and try to explore the concepts of the president. For example, see here, whatever I am talking to you now, again that is related to the concept of the bill. We know what is the meaning of the bill, and the bills can be introduced in the parliament only during the session. And during the recess period, we cannot introduce any bill. But the situation may be demanding that you need some act immediately. But at the same time, you cannot wait till the parliament is summoned. In that case, to avoid the situation, to take care of the situation, the Constitution of India has permitted the President of India to issue an ordinance. Meaning, ordinance can be issued by the President of India only during a recess and not during the session. Only when the Parliament is not there in the session, then only the President can issue the ordinance. So during that time, what exactly happens is that particular ordinance will come into immediate effect. The moment declared by the President of India, of course, again on the advice of the cabinet. The moment it is declared, it will come into effect and that will be implemented. But the condition is that once the parliament reassembles, in that parliament, it should be accepted within a period of 6 weeks. This is an important point. This is what the Constitution is saying. Once it is issued, it will come into immediate effect. And we know another point, that once the parliament is issued means, once the president issued the ordinance means the parliament is not in the session. If the parliament is not in the session, definitely the parliament should reassemble within a period of 6 months. If it is 6 months, it may happen at any time. It may happen within 5 months, 4 months, 3 months, 2 months, or 15 days. But whenever the parliament reassembles, from that particular day, the ordinance is valid for a period of 6 weeks. And within that 6 weeks, it should be accepted by both the houses of the parliament. Then only the ordinance will become a permanent act. If it is not accepted by the parliament within the specified time, within the period of 6 weeks, then the parliament is considered to be void. I'm sorry, I'm using the word parliament repeatedly. The ordinance is considered to be void. So I'll just show you the document now. Let me open the document and talk to you. Now look at this. Under Article 123 of the Indian Constitution, it empowers the president. It empowers the president to promulgate ordinances. These are in nature of temporary laws. If you look at the last point, kindly have a look at that. This is the most important legislative power of the president. But there are certain limitations. Let's try to understand what are these limitations. Number one, the ordinance can be proclaimed by the President of India only during the recess. I need not explain you these points. You know the meaning of this recess. Meaning only when the parliament is not in the session, ordinance can be proclaimed. For example, see here, as of today, the parliament is not in the session. And I was telling you in the previous classes that our parliament was prorogued on December 23rd. On December 23rd, 2014, the parliament was prorogued. The parliament prorogued means it is an end of the session. The session was ended and the recess period has begun. That's the reason, if you look at the very recent past, the president has proclaimed ordinances. And all the ordinances have been declared by, notified by the President of India after it has been recommended by the cabinet. Because cabinet is the executive authority, cabinet is the authority which wants to implement certain things. And the constitution permitted the president to do so. That's the reason the president has declared ordinances. Now, let me show you the document once again. Look at this. The ordinance can be issued only when one house is in the session. What do you mean by this? Let's see here. Let me tell you once again. Ordinance can also be issued when only one house is in the session. I was telling you some time back, it need not be necessary to have the two houses in the session every time. Lok Sabha may be summoned on different date and Rajya Sabha may be summoned on different dates. Lok Sabha may be summoned, prorogued on different date, and Rajya Sabha may be prorogued on different dates. So the constitution permitted all these things. But when I'm using the concept of this ordinance, it can also be issued when even one house is in the session. Meaning, ordinance cannot be issued only when two houses are in the session. If one house is there in the session, even then the President of India can proclaim the ordinance. Look at this one. To legislate by ordinance is not a parallel power of the legislation. So this is only a temporary aspect here. This is only a temporary aspect in order to meet the situation which is demanding for the urgent legislation to come into the picture, where parliament is not in the session. Then only the ordinance concept can be used by the government. Look at the next point. Once proclaimed, it is valid for a period of 6 months. See here, the concept of 6 months was not used by the constitution. It is our expression, generally we say that it will be valid for a period of 6 months because the gap between any two consecutive sessions of the parliament should not be more than 6 months. That's the reason it may be 6 months. In the worst case, it may be the 6 months. Meaning yesterday parliament was prorogued, today you are issuing the ordinance, and that ordinance will continue up to the 6 months. So this will happen very, very rarely. But otherwise, what is the minimum gap? Maximum is 6 months between two consecutive sessions. But what is the minimum gap between two consecutive sessions is not mentioned in the constitution. Once it is prorogued, at any time it can be summoned, but that period should not be more than 6 months. That's the reason why it may be summoned within 10 days, 1 week, 1 month, or 2 months, 3 months, but not beyond 6 months. That's the reason why we are using the word 6 months. Now look at this. An ordinance cannot abridge or take away any of the fundamental rights. We know this point already. The parliament cannot make any law which will abridge or take away any of the fundamental rights. In a similar manner, when the president is issuing the ordinance means that is nothing but he is legislating. Because the parliament is not in the session, he is coming into picture, but that ordinance cannot take away any of the fundamental rights. If that ordinance takes any if that ordinance takes away any of the fundamental rights, then that ordinance is subjected to judicial review. The judiciary will come into the picture again. Next one. The decision of the president to issue an ordinance can be questioned in a court on the grounds that the president prorogued one house or both the houses of the parliament deliberately with a view to issue an ordinance on a controversial subject. So what is the meaning of this? Because the president is acting on the advice of the government of the day, the government may ask the president of India to prorogue the parliament. with an intention to issue an ordinance, or the government may request the President of India to prorogue at least one of the houses so that it can go for the issuing the ordinance. If that is the case, even in that case also, the decision of the president can be questioned, right, in the court of law. Next one. Ordinance issued by the president must be laid before both the houses of the parliament when it reassembles. And from that date, it is valid for a period of 6 weeks. Hope you are understanding each and every point. Now, the next point is that the president can withdraw an ordinance at any time. What is the meaning? He is issuing an ordinance, and before it is passed in the parliament, at any time the president can withdraw the ordinance. Ordinance can't be issued to amend the constitution. So generally what happens, these are the things that are related to the so-called ordinance making power. Okay, so kindly remember this one. And see here, just remember, and each and every point kindly remember. In the evening today, during our current affairs session, I am going to talk to you about the ordinances that are issued by the President of India. So President has issued ordinance on 3 ordinances, and one more is pending with the President of India. So regarding them, I'm going to talk to you after in the evening session, that is in the current affairs session. Right now, let me talk to you about the other powers of the president, that is the pardoning powers of the president. Now, so they are mentioned under article number 72 of the constitution. Yesterday I was talking to you something called the judicial powers of the president. So that is nothing but the president is seeking the advice from the Supreme Court, and the president is empowered to appoint the judges of the Supreme Court and High Court, we have discussed. And apart from this, we also have the pardoning powers of the president. What do you mean by these pardoning powers? I told you yesterday, I gave you a brief introduction, but today let me talk to you in a detailed manner. Once a person is accused, the police will be arresting this person, and he is called accused, and an accused will be placed before the judiciary. And the judiciary, either it will convict the person or the person may be acquitted. I need not tell you the meaning of this because you know the meaning of each and every word I am using it. If there is any confusion, please go back to the previous classes and refer the previous videos. Now, the judiciary will decide whether the person is convicted or acquitted. If the person is convicted, then only the person will be given the sentence. And if the person feels that, so it's a wrong judgment, or he was given more punishment, or unfortunately he was framed, or he was convicted in a wrong manner, then he has every right to approach the higher judiciary. That's the reason from lower court, he has the right to approach the high court. High courts are present at the state level. And if he is also not happy with the judgment given by the high court, he still has the right to approach the Supreme Court. But as the Supreme Court is concerned, the judgment that is given by the Supreme Court is considered to be final. And the person has the right to go for the review petition in the Supreme Court. And after that, depending on the interest of the person and the permission given by the Supreme Court, a person may also be asked to approach the President of India. That all depends on case-to-case basis. So what do you mean by this? Constitution is permitting the interference of the President of India with respect to the judicial issues. The judgments are given by the judiciary. But in judiciary also, these are all the group of human beings. There may be a possibility of the human error, and because it is happening in judiciary, we may call this as judicial error. So in order to rectify this error, the president has been given the powers under the constitution to look into these petitions. And kindly remember here, a person is empowered or allowed to approach the president of India only after getting exhausted with the judicial proceedings. So whenever he wants to approach the president, he will be approaching the president with a petition, and that petition is called mercy petition. Depending on that one, the president will be taking certain decisions like, number one, either the president will be rejecting the petition. Number two, the president may be reducing the punishment. Or number three, the president may cancel the complete punishment that is given by the so-called the judiciary. So depending on what is the decision that is taken by the president of India, the constitution has given 5 judicial powers, rather they are called 5 pardoning powers to the president of India. They are mentioned under article number 72 of the constitution. And now, so we are going to talk about that one. I'll show you the document and I'll explain you now. Now look at this. Look at this. The power of the president under article 72 is independent of judiciary, meaning the judiciary cannot give any directions to the president of India. The basic idea is to correct the judicial errors. The president does not function as a court of appeal. The president can't be compelled to give a hearing to a petitioner. No, you cannot compel the president of India. Next one. The decision of the president, if final, and courts cannot interfere the decision of the president. But the courts can look into whether the president has considered all the relevant material or not. See here, so this is not F please, this is the is, right? The decision of the president is final and the courts cannot interfere with the decisions, DECISIO, decisions of the president. What do you mean by this? Because the case is going to the president of India, after the completion of the judiciary, so the president is taking certain things into consideration. Meaning in this particular statement, we are saying that judiciary cannot interfere with the judgment, but the courts can look into whether the president has considered all the relevant material or not. Meaning at the end of the day, I am trying to talk to you whether the judicial interference is permitted or not, whether the judicial review is permitted or not. Kindly remember, once we exhausted with the judiciary, then we are going to the president of India, and any decision that is taken by the president of India is subjected to judicial review. Meaning the president might have taken a decision. I'll tell you some examples after some time. The president may take certain decisions, and within what time you are taking the decision, that is also important. Already in the judiciary system, so the cases are pending for a long period of time. But under article number 72, how long the president can retain the case with him or withhold the case with him without giving any judgment on this. The constitution is silent. That's the reason in the year 2012, the Supreme Court has questioned the government of India how long the mercy petitions can be withheld by the president of India. Is there not any time limit on this? During that time, the government replied that there is no time limitation with respect to the withholding the mercy petitions. That's the reason in some of the cases, it may be taking 2 years, 3 years, 5 years, 10 years, or 20 years. Because nothing is mentioned in the constitution, the president can withhold the decision, or there can be inordinate delay in the decision of the president of India. I told you already, it is not the president of India who is taking the decision. It will be again given back to the government. Finally, in the Home Ministry, it will be considered. And according to the recommendation that is given by the Home Ministry, the president will announce his decision. That's the reason, sometime back, if you see, the assassins of Rajiv Gandhi, Shantan, Murugan, Perarivalan. So these are the three people who were arrested immediately after assassination of Sri Rajiv Gandhi, the late Prime Minister of India. And these people were convicted by Tada court in the year 1994. And the Tada court has given the death sentence. And immediately they have submitted a petition to the Supreme Court. And Supreme Court in the year 1999 confirmed the death sentence to all these three people. And in the year 1999, Shantan, Murugan and Perarivalan, they have submitted mercy petitions to the President of India. Since 1999, the mercy petitions were pending in the Rashtrapati Bhavan, and finally in the year 2011, the mercy petitions were disposed. So during that time, the general apprehension, the general understanding is that because there is so much of delay, so there is always an expectation that the president may be reducing the punishment or the president may be cancelling the punishment. Of course, in such type of cases, cancelling the punishment is never possible. At the most, you can reduce the punishment. So these death sentence can be reduced to the so-called the life imprisonment. But unfortunately, what happened in the year 2011, the then president, Srimati Pratibha Patil, announced that she is rejecting the mercy petitions of all the three. Now the criticism is that if the Rashtrapati Bhavan wants to reject the mercy petitions, why did you take so much of time? You should have rejected all the mercy petitions within a very, very short period. Maybe within 1 month, maybe within 1 year, maybe within 2 years. Why did you take so much of time during that time? And once the decision has been announced by the so-called the President of India, the dates were also announced. In the month of September 2011, these three people were supposed to be hanged. But these three people have approached the Madras High Court, meaning there is a possibility of the judicial review in this. During that time, the petition was accepted by the Madras High Court, and later Madras High Court requested the Supreme Court to transfer the case from Madras High Court to the Supreme Court. Because the situation in Madras is so sensitive, Supreme Court permitted that the case be transferred to the Supreme Court from Madras High Court. And finally, in February 2014, the Supreme Court has given a judgment. Kindly remember here, these three people were given the death sentence and the president has rejected the mercy petition. Later, Madras High Court has accepted the petitions of these three, and again the case has been transferred to the Supreme Court. So finally, in February 2014, the Supreme Court has announced that the Supreme Court has the power, or the judiciary has every power, to reduce the punishment from death sentence to the life imprisonment based on the reasons of inordinate delay that is caused in the Rashtrapati Bhavan. Clear? So the case is related to 1991 and the Supreme Court has given its final judgment in the year 1999, and since then for quite a long period of time it was pending in the Rashtrapati Bhavan. Supreme Court has cited just one example, inordinate delay. But otherwise, looking at the crime, looking at the nature of the crime, they deserve the death sentence. But because of this particular inordinate delay, the judiciary has announced that the death sentence of all these three, Shantan, Murugan and Perarivalan, is converted to or is commuted to life imprisonment. Meaning, this is the judiciary that will interfere into these matters. Kindly remember, judiciary is coming into the picture again for the second time after it is exhausted by the judiciary. After the president has given the final decision, again the judiciary is coming into the picture. Meaning the fundamental idea is nothing but a person should not be punished and he should be given the chance till the last moment. Meaning, once you kill a person, we cannot get back the life. That is the reason, as long as he was alive, enough opportunity should be given to him. So that is the basic idea. And so that is what is happening in India now. Now, look at this. I'll show you the document again. I told you just now, depending on the situation, the president will be using his pardoning powers. Let me type something on the screen. Have a look at, please. Now, I'm talking in terms of the so-called this penalty. Here, when I'm using the word penalty, this is nothing but this is the lowermost punishment. Lowermost punishment. And above this one, you have something called simple imprisonment. This is called simple imprisonment. So this is the next higher level form of punishment. Or next will be life imprisonment. Life imprisonment. Now, next one. And the final punishment is a death sentence. This is called the capital punishment. Now, kindly remember, so I'm just highlighting this. Now have a look at this. Lowest form of punishment is a penalty. Next highest is a simple imprisonment. Next one is the life imprisonment. And the highest form of punishment is the death sentence. Now, the point is that the Supreme Court may confirm any of these punishments. But on what punishment I can approach the so-called the President of India? On anything a person is permitted to approach the President of India. Depending on the decision taken by the President, these pardoning powers are of 5 kinds. Kindly remember all these points: penalty, simple imprisonment, life imprisonment, death sentence. Now the judiciary has been exhausted. Now the person is going to the President of India, and the President is taking some actions. And what are they? Look at this. Sometimes the President may be using his power called pardon. This is called pardon. What do you mean by this? I'm just reading out the statement. Kindly follow me. This removes both the sentence and conviction and completely absolves the convict from all sentences, punishments, and disqualifications. Simple point, because you know the terminology of each and every word, it becomes so easy for you. Pardon means it is removing both the sentence and conviction. What do you mean by sentence? The punishment that is given by the judiciary. Conviction means the judiciary has approved that this person committed the crime. So once the president is using pardon, that conviction is also removed, sentence is also removed, and the person is completely absolved from all sentences. Absolved in the sense he is completely freed. No punishments, no disqualifications, no sentence, nothing. Meaning he becomes completely free and no punishment is given. This is a very, very powerful judicial powers of the president with respect to these cases. Am I clear? So this is the highest form. Next, second one I am talking to you. So this is the commutation. What do you mean by this commutation? This is the substitution of one form of the punishment for another of a lighter character. What do you mean by this? Here I have given something. For example, if it is a death sentence, if the president is using the power of the commutation, death sentence is substituted by a lighter form of punishment, meaning immediate lower form of the punishment. When I'm using immediate lower form of punishment means death can be substituted by rigorous imprisonment. If the punishment given by the Supreme Court is a rigorous imprisonment, by using the power of the commutation, the president may substitute rigorous imprisonment with the simple imprisonment. If it is simple imprisonment, the president may substitute simple imprisonment with the penalty. But If the punishment given by the judiciary is a penalty, then the president cannot reduce it. Because if you remove the penalty completely, that will be coming under a pardon. But here I am talking to you regarding commutation. So that's the reason why one form of the punishment or the other form the person has to undergo. That is the reason it is called substitution of one form of punishment for a lighter form. Very, very important. Okay. Now look at this. So I have something. Let me read it for you. Adbir Singh, he was lodged in Tihar Jail, New Delhi, is the first death row convict whose sentence has been commuted to life imprisonment by the President Pranab Mukherjee on November 15th, 2012. Otherwise, here, by the time Mr. Pranab Mukherjee becomes the President of India, there are so many mercy petitions that are pending. But Adbir Singh, who was there in New Delhi in Tihar Jail, he was the first person who got the commutation from Pranab Mukherjee. Now look at this. Just a moment. Now, so this man was convicted and sentenced to death by a sessions court in 2004 for murder of his stepmother and stepbrother in 1996 over a property dispute. Is it okay? So he did a crime in 1996 and finally he was convicted in 2004. The High Court confirmed the same in 2006 and Supreme Court dismissed his appeal against the sentence in 2010. The Ministry of Home Affairs recommended as the crime had a social economic basis. So meaning, so because, see, the reason may be anything. So it is always important to look at the background of the issue. So he was not a terrorist. He was not a person who is an habitual offender. But the issue is related to the socio-economic basis. That's the reason why the Ministry of Home Affairs recommended for commutation and it was accepted by the president. Right? Now, look at this. Remission. Now, the next one is the remission. What do you mean by this remission here? Remission is nothing but the reduction of the period of a sentence without changing its character. Kindly see here, when I'm talking about the character means penalty is the character, simple imprisonment is the character, rigorous imprisonment is the character. Now, once a petition goes to the President of India, if the President of India wants to issue the remission, the meaning is that if the person is given a rigorous imprisonment for 5 years, then the President will give an order saying that he need not undergo rigorous imprisonment for 5 years, but it can be substituted by 2 years of rigorous imprisonment. See, here, the nature of the punishment is not changing. Character of the punishment is not changing. Rigorous imprisonment is given by the Supreme Court. And the president is also confirming the rigorous imprisonment, but the amount of the period, how long he should be there behind the bars, is changing here. Meaning the president is reducing the period of sentence. Then it is called remission. Kindly see here, in commutation, we are substituting higher form of punishment with the lower form of the punishment. But whereas in remission, the character of the punishment is not changing, but we are reducing the so-called this sentence. That is the reason a simple imprisonment of 1 year may be reduced to simple imprisonment of 6 months. A penalty of 10,000 crores may be reduced to a penalty of the 5,000 crores. Kindly remember this one. Remission is not applicable for the death sentence. All right. Next. Look at this. For example, here there is another power that is used by the President of India that is called respite. Respite means awarding a lesser sentence in the place of originally awarded one because of some special facts. What do you mean by the special facts here? Now, generally what happens, whenever the petition goes to the President of India will try to look into the case. But certain petitions will be coming in such a manner where the President is also looking into the certain facts. For example, say, what is important for the judiciary is the evidences available on that particular time. During that time, Maybe a pregnant woman has been given the death sentence. Obviously, it is inhuman to give the death sentence to the pregnant woman. So obviously, the fetus that is present in the womb of the lady is also killed. That's the reason why, if example I'm telling you, if such type of cases are going to the President of India, then the President of India will be using this power respite. Whenever the President uses the word respite, the meaning is that the President is reducing the punishment, meaning death penalty may be reduced to life imprisonment. But here sometimes what will happen, if it is rigorous imprisonment to a pregnant woman, again she cannot undergo that one. That's the reason why the death sentence may be reduced directly to the simple imprisonment, nothing to do with the background of the case, but the president is taking the special facts into consideration. That is the important point here. And the last one more thing we have, we'll look at that. Kindly have a look at this. Now, reprieve. So whenever I use the word reprieve, in reality, whenever any mercy petition reaches the President of India, the first power that is used by the President of India is the reprieve. See here, if a person is given a death sentence, he will be lodged in one of the jails. And in that jail, the jail authorities will make all the arrangements for executing the person. But if the mercy petition reaches the President of India, the first thing that is done by the President is to issue a stay order. Stay in the sense, President is giving an order for stopping the execution. Don't kill him. Because his petition is pending with me, don't kill him for a period of time till further orders are released by Rashtrapati Bhavan. Am I clear? That is the meaning of the reprieve. That is the reason the people who are given the death sentence, so they'll be lying behind the bars for quite long period of time. Once mercy petition reaches the President of India, the first one that he is issuing is the reprieve. So he's giving instructions to the jail authorities to not to execute him because his petition is pending with me. Is it okay? So now, apart from this, we also have some more points, and we'll have a discussion in the next class. And kindly see here, our next class will be again on Monday, and on Saturday and Sunday we are not meeting. We'll be meeting again on Monday at the same time, that is at 5 o'clock. Okay, so take a break for 2 days, Saturday and Sunday. But if there is any possibility, you kindly revise some of the videos. Am I clear? So take care and have a very good day. So thank you so much for being with me this morning, and I'll see you. For public administration students, I'll be meeting you at 7 o'clock now, and for current affairs, I'll see you in the evening at 9. Thank you so much once again. Take care.